My guest today on Behas with Barkha is one of the country's foremost lawyers. We also have seen him in his role as a politician. But in this particular interview, I think for all students of law, but also for people like me who are not lawyers but are interested in all the issues that come out of our courts, this is essential reading. From the Trenches by Abhishek Singhvi is India's top lawyer on his most important cases. Abhishek, for a lawyer to actually choose from a huge body of work, a handful of definitive cases as you've done, I must first ask you, what was the basis on which you chose these 7 to 8 cases?
To be honest, it's a huge dilemma. It's virtually, I mean, it's not exactly, but virtually like choosing amongst your siblings or children, which is an unfair choice. Fortunately, a large part of this was done. The idea came, to be very honest, from the publisher Chiki Sarkar Juggernaut. And the style and the very, very simple way of stating it is her idea for the non-lawyer, for the layman.
Yeah.
She also chose, and my co-author, the person whom I dictated, who made it, and then, who redid it with me, and then whom I checked and corrected and all that, Satyajit Sarna. They sat together and decided that what is important and seminal in constitutional law, public law, but intersects with importance for the life of the nation and for the ordinary man of interest.
Yeah.
So these three intersections are broadly the choice if you are forced to make a choice. Of course, I have a host of other cases I might have liked to include, but the length of a book and the number of chapters doesn't permit it.
So the good thing about the book is that whether or not you know any law or jurisprudence, it's actually very easy to read and understand. And I guess that was the whole point of it. So let's start with the one case in which it's gone in your favor. It looks like that might even be the eventual verdict. And it's the one place where I completely disagree with you, which is the Sabrimala case. Now, in Sabrimala, just for our viewers' perspective, you have basically argued in favor of continuing the practice that menstruating women between the age of 10 and 50 should not be allowed at this Ayyappa shrine, because Ayyappa, by definition, was a celibate god and therefore it is particular to the deity. When the court first said that women should be allowed, one of the arguments that some judges made was that this was not a separate denomination. But Justice Chandrachud took it a step further and he spoke about constitutional morality. Do you not agree, Abhishek, with that as a way to understand religious practices in modern India?
2 or 3 very quick caveats and then the answer to you. And I don't want to sound technical, although this particular case does involve some technicality of law. First, there's the old saying, lawyers don't choose their clients and lawyers should not and do not judge their clients. So a brief I do doesn't have to be one I believe in, and it also doesn't mean that I go and choose that I like your brief and I don't like that brief. Sabrimala is the brief which came to me. I argued the first one, 5 judges, we lost 4-1.
Where the woman was the dissenting, Justice Indu Malhotra was the dissenting.
The second one is the review, which we have in a sense succeeded because the review doesn't decide the matter again, but it reopens it.
Right.
Now it's the third one, ironically starting Monday,
the
17th.
Constitutional bench.
Before the Constitution bench, where by the way, because the 9 judges, not Constitution, 9 judges, all the issues can be re-argued completely from 1950.
And not just Sabrimala, but every time religious practices
collide. Not only that, you are not bound
with
by the large 5 judges previously or 7 judges who have decided. That's the 3 question. Now, the answer to your question. My principal contention, which we have lost once, won once partly, and we hope to now win. And at the council, because obviously, whether I believe it or not is irrelevant, is that and I'm trying to oversimplify it, there is a very wide arc of religion guaranteed to you the Constitution, profess, practice and propagate. That religious arc, you like it or not, can't be cut down. 2, you have to decide first whether it's religion.
Yeah.
Obviously, if it is not religion, then you out you go. But assume that a religious denomination called Ayyappans is a recognized, and that's where Justice Nariman and Chandrachud have hit us, saying they are not. But the argument obviously will have to be accepted that they do constitute a religious denomination. I say they do because this temple is the single sole out of 1400 or 1100 temples, I don't remember the figure, in India of Lord Ayyappa, which is in the one form anywhere in the world, an eternal, permanent, neshtik brahmacharya pose. Number 3, if you are able to propagate a practice which is intrinsic to the nature of the deity, then I say it is protected. Now, we are not excluding women. Be clear. Women...
You're excluding women of a reproductive age.
Yes. So the segregation is not between men and women. That would be bad. The segregation is between all men and women of below 10 and above 50 on the one hand versus 10 to 50. Now the 10 to 50 exclusion, so long, this is the heart and core of the legal proposition, so long as the 10 to 50 exclusion has a direct nexus, an inextricable nexus with the nature of the deity, then it is protected. But it has to be obviously a religious practice.
Right.
And we believe it is.
So here's the point. I want to say two things to you. One, as a woman, I find it extremely problematic that menstruation, which is already used as a basis for stigmatization, and we just saw this horror story of a Gujarat school that made young women actually show their underwears to show whether they were menstruating or not, should be any basis for any kind of discrimination. One. Two, you say that the most important thing to establish by law is whether it's a religious practice or not. I put it to you and I want you to explain this to me. All the changes we've seen the court make to religious practices in the recent past, let's take triple talaq. The Supreme Court argued triple talaq was not an essential tenet of Islam. In the Sabrimala case, when it first said women of this age should be allowed, a similar argument was made that neither is the Ayappans a separate religion or religious denomination, and thus this is not an essential religious practice. Right. I say to you, Abhishek, tomorrow let us say there is an essential religious practice and it is completely unequal for men and women, or let's say for Dalits. What would we do?
Exactly. It's a very good question. First, this whole thing is getting conflated and confused because we are splitting between 2 points. Is it religious practice?
Yeah.
And if so, is it protected?
And should it matter? I'm asking you, should it matter?
So let's leave the first part. You have to test this by assuming it's religion, right? Because if you are proved not to be religion, then you're not entitled to the protection anyway. So leave aside that part. If we fail to establish that Ayappans are a religious denomination, matter ends.
Yeah.
Now your question is more important. Assume Ayappans are a religious denomination.
Yes.
A practice which is according to antithetical to civilized norms of behavior should not be protected. Now that's where the rub lies. There are certain articles of the Constitution which are entrenched as part of our fundamental rights, precisely to protect that which is considered by the majority or by all non-adherents to be bad. So long as, test it simply, take an example where you concede that it is a core part of a known religion, X, call it X. It is abhorrent to 90% people. The whole point of Article
90% people within that religious denomination?
No. It can't be, because there is a religion called X you are conceding and there is a practice that called X. Now you assume that religious practice is abhorrent to the rest of the world, entire world, 90%. But religion bona fide exists and religious practice exists and adherents follow it. In that case, the crux of the matter, which is difficult to understand, I understand, you can't apply an external test. Religion being a matter of faith, provided it's religion, it is given a full protection. Now, the second point is even more important.
I question why that should be the case.
That's because the Constitution says that.
But the Constitution...
Right. Constitution, the debate says so, the article says so, that a religious belief, howsoever bad to an external element, provided it is part of religion, you can't rewrite the religion.
Let me give you an example. There were religious groups of different faiths that tried to stop the decriminalization of homosexuality.
No. That's not religion, no. Trying to stop your homosexuality in consensually behind closed doors is not a religion. It can't be protected. Take an example where, for example,
female genital cutting, which is before the court.
No,
female genital cutting among Bohri Muslims.
Right.
Now there is a whole women's movement on, as you know, to stop this, I think, abhorrent practice where 7-year-old kids are taken by their grandmothers to have their genitals cut.
We've jumped topics.
No, because it's all interlinked.
I am the lead counsel there also, by the way, in this batch. First, it conjures up a mental imagery, an optical imagery of FGM.
Yes.
You know, my primary objection is what?
Is mutilation. Calling it mutilation, I called it cutting.
No, not mutilation. No, please listen. FGM is an African cannibalistic tribal practice.
Yes.
FC is the right word. Do you at all object once, Barkha, when there is compulsory male circumcision amongst all
I actually think I would object.
You're right.
I would object because I think that if, for example, there was a community movement tomorrow of little boys saying this was not our choice.
That's the whole point. I would equally object. The law says that the fact that you and I, as external agents, object will not change the religion at all. The whole idea of protecting religion is that you are a minority, you are a religion, you are a belief.
Abhishek, clergies have been traditionally male-dominated clergies. Therefore, your example on circumcision is...
We're going beyond law. Can you rewrite the Quran? Can you rewrite the Gita?
The interpretation has never been agreed on. I have seen different scholars interpreting the same
so that's a different issue.
sort of tenet completely differently.
People decide, is male circumcision a religious practice or not? Once you say male circumcision is, then this is a established practice amongst two kinds of Shias, namely Bohris and one other group, which the Fatimid school so-called, which allows female circumcision. It is not mutilation. The problem is FGM conjures up. It's a phrase deliberately taken by the opponents from African practices.
What about the women who have come up and said that we do not like what happened to us? There are also women who say that we are fine with it.
No, but do you know this? Do you know this? I'm doing the actual case. And we have now an intervention application in writing in the court for the last 4 years. That of the two categories of women you talked about, there are in all a number of 3 which have come in the whole community to the court. And there is a number of the whole community is only a few lakhs, you know that, it's a very small community. More than 60,000 women collectively have filed that we support this practice because we as parents tenderly and with care do female circumcision, which is a form of doing a nick on the prepuce and is nothing to do with mutilation. So how do you decide? The problem is not this. I am not a number that my 60,000 versus Barkha's 3. I am saying even if it was 3, once you consider it as religious practice, the whole purpose of Article 25, 26, you can't look at it.
No, which is why I agree with Justice Chandrachud's argument that there has to be a larger morality.
Right.
You are suggesting...
Now that issue, the 9 judges will decide.
No, 1 minute. You are suggesting that the moment you establish that something is an essential religious practice, whether Abhishek Singhvi or Barkha Dutt like it or not, becomes irrelevant.
That's one. Very good. But now I'm going further. You use the word essential.
Yes.
The current law is that, what you said.
Yes.
Once you establish something to be essential religious, then whether you like it or not, indeed, external elements within the religion like it or not, it can't be changed.
So when 25 collides with 14, what happens? When right to equality collides with the right to the practice of religion.
We are now arguing before the 9 judges that there is no such thing as essentiality.
Yes.
The article says you can restrict. Suppose a religion has a cannibalistic practice.
Yes.
The better example should be that. Obviously, it will be stopped. Why? It is a genuine religion. People believe genuinely in it. Why should it be stopped? Because there are 3 derogations permitted. Public order, morality and health. A cannibalistic practice hit 2 of the 3 or all 3 perhaps. However, absent that kind of a practice which does not hit. So suppose a practice is kosher, public order, health and morality. Then the constitution and the framers never used the word essentiality. Do you know where the essentiality came from? And I'm arguing it Monday, Tuesday before the court. That essentiality is a false test. Why? If a practice is religious, it is fully protected, even if it is non-essential. But if a practice is not religious, it is not protected, even if it is claimed to be essential. However, if a practice is a religious practice and it hits public order, it will not be allowed.
But do you not think this is an evasive way of settling things that are quite open and shut? Let's take triple talaq. In triple talaq, the Supreme Court had to again argue this is not an essential tenet of Islam. I'm saying, let's say somebody argued it is an essential tenet of Islam, but you know what? In 2020, it needs to go.
As the law today stands, you have to take a call and the court takes the call. Is it essential or not? Now, it is found that triple talaq is not an essential practice. Matter ends.
But is the court the clergy? Is the court, and you raise this question in the book,
should
the court be the arbiter of faith?
Now, what happened was there were 7 judges in Shirur Mat. They made a distinction between, way back in the 50s, between religion and practices which are non-religious but associated with religion. So religious practice is worship, but keeping ledger accounts for that worship is a secular non-religious practice. That's all that they did. The judgment came after that called Dargah Committee, 5 judges, which misinterpreted that judgment to say, instead of religious versus non-religious, within religious, we call it essential and non-essential. That argument we are now making before 9 judges starting next week to say, there is no such thing as essential and non-essential. Suppose a practice is essential. And suppose it hits public order. Assume a practice is essential. It is essential to beat a woman in a religion. And it clearly hits public order. It will be not allowed. So what are the use of saying essential? Suppose a practice is non-essential and it doesn't, but religious. Suppose a non-essential practice is religious. It doesn't hit public order, morality and health. It will be protected. So essentiality is a red herring.
Who decides
essentiality is a red herring, which we are now trying to re-argue before 9 judges, because 5 judges before have misinterpreted it.
I think essentiality is an excuse for the court to step into personal laws that it doesn't have the space to
so
step
I agree
into.
with you to that limited extent.
Otherwise.
While we have been disagreeing earlier that essentiality is a red herring test superimposed by the courts who cannot decide. There I agree with you.
Okay, now there's another contradiction I find in your book. One of the other cases that you pick up is the Jallicut case, right?
Yeah.
And as an animal lover, you say how disturbed you are by this mass cruelty towards animals. But in Jallicut, you saw the kind of, again, sentimental, cultural, societal backlash. It almost became like a regional pride sort of issue. And the law was again in collision with a larger dominant sentiment that you and I may find distasteful.
See,
is this not the same? How does the same Abhishek Singhvi say in Sabrimala, right, that this is tradition and it doesn't hurt public order, but in Jallicut argues exactly the opposite?
The first humorous and superficial answer is the same one. Lawyers do not choose their clients, they don't judge their clients. But this is a case where my choice of client and my
coincides with your actual belief.
Perfectly coincide.
Okay.
Number one. Number two, why you are wrong is there was no religious right involved in Jallicut.
So custom is different from religion?
Totally, because it is a strong right. As an animal lover, I feel strongly about it. You as a Keralite with a custom right may feel equally strongly about it.
Yeah.
But rightly or wrongly, there is no article in the Constitution which protects that kind of a customary right. That's number two. So you are not having a collision between a constitutionally sanctified right of religion versus something else. The third most important is missed out. There is an act in our country which is already a statute.
Yeah.
Now statutes have to prevail unless you say that a superior constitutional provision is violated by the statute. The act in question here is the Animal Cruelty Act. So under animal cruelty, if you are an animal and I do cruelty to you.
Yeah.
Unless you show that article which allows me to do not to do cruelty against you, it violates the Constitution, that
but I can argue the same in Sabrimala.
Now Jallicut is cruel under the Animal Cruelty Act.
But in Sabrimala, I can say that as a woman who wants to go to Sabrimala, only me, Barkha Dutt, wants to go and pray at Sabrimala. Under Article 14, I am entitled to that equality.
Right. Now, there the argument is, now you have shifted from 25 to 14, absolutely right, that's the heart of the matter. 14, the answer will have to be decided by the court. The answer is simple. 14 permits classification, permits different classes to be made, but does not permit discriminatory classification or arbitrary classification. And this is the crux of the matter on 14. There is no classification in Sabrimala between women and men. So if I said women can't go, men can go, possibly you'd be right and we'd be hit by 14. What I'm saying is all men can go and all women below 10 above 50 can go. Only the 10 to 50 on grounds of fertility, which is antithetical. It's an oxymoron and antithetical to allow 10 to 50 women with the fertility symbol to go in a temple which is an only 1 out of 1100 for the eternal Nashtik Brahmacharya form. Now you cannot have, it's like saying that you have a DT for fire and you allow water to always go there.
No, but
that's the whole point.
But as you mentioned in the book yourself, there are women who are not allowed to enter the puja rooms of their homes when they're menstruating. You're not allowed to touch the achar jar. Now, I just feel that this kind of thinking perpetuates a kind of stigmatization of the monthly period. So I have a disagreement with it. But what bothers me more on a point of law?
Objective standard, no? You're applying an objective standard.
Yes.
The moment you concede that Ayyappan sect is a religion,
I can't apply any objective standard.
No.
And how are we okay with that?
You can.
How are we okay with that?
Not can't. You can apply 3 standards.
What if a uniform civil code? What if a uniform civil code?
Morality and public order.
Here's the question. What if a uniform civil code were to be legislated by this government?
I'll tell you straight away. Why?
Okay.
It will be protected because there's a
What
reverse.
will be protected?
I'll tell you. In stark contrast to your Article 25 and 26 on religion, which allow you to raise this point, provided you can bring it under public order, morality or health. The reverse is true in UCC. The UCC, if enacted, there is an exhortation in the directive principles.
Yes.
So, there is no right to the contrary in our fundamental rights.
You could have a new law. You could have a constitutional amendment and a brand new law.
No. If you repeal 25 tomorrow, you can.
Yeah.
Well, why can't you repeal part 3? Take away all the fundamental rights. There's a basic structure. Suppose I say, you shall not have a right to life.
Yeah.
So that's a different argument.
Yeah.
But the answer to UCC is what? Uniform succession laws, uniform marriage laws, uniform marriage certificate laws. First, you have to prove it is a part of religious violation. If you show that any of this UCC clause is intrinsic part of Islam or Christianity, then maybe it will be hit by 25. But on the contrary here, UCC does not violate any part of 25 And reverse-wise, there is an exhortation and directive principle saying, please have a UCC.
But what you're effectively saying is our constitution protects religion to the extent that no objective standard can be applied to change
Once
it
it's religion.
if established it's a religious practice.
That's the crux of the thing. That's the heart of what you're saying.
Disturbing. The other thing that's disturbing is...
Disturbing to your standard and my standard.
Yes, but the other thing that's disturbing is both in Jallikattu and Sabrimala, you actually have the court almost helpless before dominant public opinion.
I partly agree and partly disagree with you. I don't think that should be the law. I don't think that should be the approach. Ultimately, you know, the old saying, let justice be done even if heavens fall. But in actual practice, obviously, courts look at consequences. They don't expect heavens to fall. Otherwise, the court judgments do change to prevent heavens falling. I don't find anything in Jallikattu which would have justified the heavens falling syndrome. What did you do? I'm not saying right or wrong. In case in Jallikattu, you stopped what I consider a cruel practice is not relevant, what you consider a cruel practice. But if you found it violating the Animal Cruelty Act and you stopped it, well, you jolly well have to stop it. And there is no business for a court to bed this way or that way.
Okay, I'm going to move focus to another case, perhaps one that maybe a lot of people who are, you know, obsessed with contemporary news do not know, which is the DK Basu versus West Bengal case. It's very interesting for me. It was learning to understand that these guidelines that we now see at police stations, basically us knowing our rights, the
10 commandments, the 20 commandments now,
emerged from this. Now, let me draw your attention to a recent encounter killing that took place in Hyderabad, where men accused of having gang raped a young veterinarian were shot. And there was a huge debate, but public opinion said, well done. Where do you pick up a case like that and reconcile it with this case?
Let me summarize my response in a few sentences. A very important question is not easily capable of an answer. We can have a whole program in this.
Yeah.
It was a joy to do this as the amicus. See, law is only a mandate. It doesn't mean, suppose you say thou shall not rape in law or thou shall not murder. It doesn't mean you are eliminating murder and rape from the country.
Yeah.
Now, these are most horrendous events because it raises the larger issue of who will guard the guardians.
Yeah.
So a death is bad, a murder is bad, a rape is bad. But it is trebly and quadruply bad if it is done in custody by the person who is supposed to be your guardian. Having said that, I have given recently and written for the last 20 years on my favorite theme of backlog or beating the backlog or arrears.
Yeah.
So one of the things I say in a slightly lighter vein is that if you are not able to deliver justice, then there can be no justification for the Hyderabad reaction of the public. There can be no justification for street hanging, lynching by the nearest pole. But there can be an understanding of it.
So not understand the emotion, not justification.
The emotion. Why? You are having ADR. Alternative dispute resolution is becoming alternative dispute resolution of the streets.
Yeah.
You have 3 crore cases pending. There is cynicism. 2.5 are pending out of those 3 at the lower level. I don't consider the High Court to be lower level. People believe that yes, ultimately in the fullness of time you may get. 50% chance are you will not get. And if you get, by that time everybody will be dead, including the accused probably. So that sentiment, there is absolutely no two views about it. I condemn this view, but I understand it.
What did you feel when you read about these alleged rapists having been killed? Because what worries everyone, of course, is what if they were not the right people?
No, you can't carry it to any logical conclusion. You can't carry it to step 2. I can't. You see, taking your vigilante justice in your own hands will create chaos. But what it is a signal and a message to the judiciary to set their house in order.
Would you punish the police officers who were responsible for that encounter?
Absolutely. Absolutely. I would punish. Let me give you, not that I mean it, a stark example. Maybe 90. See, I'll give a very quick example because it's a very important question. On the day 31st October 1984 when Mrs. Gandhi was assassinated, I was in England. I don't think there was a single person on planet Earth, not one single, who did not believe that those 3 Sikh gentlemen had killed her. Not on planet Earth. Do you know, all 3 were given death sentence by the trial court. 1 was given life and 2 maintained death sentence in the High Court. And did you know, Barkha, that 1 was acquitted by the Supreme Court? Now, suppose you and I, in anger, had killed that one man.
Yeah.
See, the problem is that you cannot have, most of life is grey. What you is black and what to me is white is not actually black and white. So you can't be judging your own cause. Therefore, you have to have an absolute approach. Howsoever strong your emotion, which I can understand, but not condone. You can't take a gun in your hand and do it. But your judiciary, which otherwise is excellent, has a wake-up call for the last 20 years. And it's very simple. You have 400 plus out of 1100 judges in High Court vacant for a country of 125 billion. Why can't you appoint them? Stop the politics. Today you have large numbers who are approved by the recommendation of the collegium and after approval are spending 1 year.
But you saw Justice Sikri's statement saying the collegium, the latest voice to say the collegium is not working as it should.
At all times it's independence. Forget, I'm not talking politics.
Do you believe the collegium is working?
It's failed. I am not talking about...
The collegium system has failed.
Absolutely. I'm not talking about this government or
that
government.
What's the alternative?
Immediately. I am saying that two statistics from 1950 till today at no point have less than 33+% of High Court been vacant. At least 33 to 40% have been vacant. At all times. At no point have 25% or less been not vacant in the lower judiciary. Now with that you can't. Now collegium is a good system because it's a reaction against executive primacy. But we have tried it. We have seen very bad politics in it. So the new system NGAC may be equally bad. But the time had come to try it. Now I understand, I am a very disciplined person. Once the NGAC has been struck down, I am a law-abiding citizen, we must follow the collegium. I don't agree with it. I find too much politics there, but we must follow it. But then if you are following it, it can't be that Barkha says by law, consultation means concurrence means consultation means concurrence or veto, and then Barkha doesn't appoint. You can't have it both ways.
So you're saying the collegium is not working, but it's the only system we have so far. So make it work.
Since now that debate is sterile.
Yeah.
You have to jolly well make it work. You can't lament. You can't afford. The people can't say that you have the power and you're keeping vacancies.
Okay, let's finally come to one of your most high-profile cases, which was the Ratan Tata Cyrus mystery battle. And just when you thought it was like curtains, it has been opened in a sense
very
again.
Interesting. Yeah.
It is a very interesting thing. Now, we can argue this in many ways. In your chapter, you actually explain it through shareholding, the value of the shareholding, the difference between equity shares and preference shares and so on. But I want first this to be a general question. Ratan Tata is this towering figure. What a lot of people can't understand and may choose this to see this battle in terms of is Ratan Tata being unable to let go.
One sentence before I answer. 2 chapters in this book are very interesting. Bang in the middle of it going to publication.
Yeah.
The judgments changed.
Yes.
Sabarimala and Tata.
Yes.
So there is obviously some mismatch because there's nothing you can do out of book in print.
Yeah.
In fact, it did twice in Tata. When it went to print, we lost after 1.5 years in the appellate court. By the time the book became ready, we got to stay in the Supreme Court.
Yes.
So it's a funny situation. I appear at all levels. I think it's unfair on a man whom I know for a while, and this is obviously subjective, you may not agree with it. He's an impeccable gentleman. And I think the only fault with him is he's too much a man of honor. There is no question of letting go. What was he doing? He was doing nothing. He was only a father figure. And it is a mistaken... See, I am a counsel, so you can discount what I am saying. There are a lot of canards spread about it because there's a lot of ego involved in this. All that he wanted was that the Tata spirit, which emanates from the trusts, goes to the Tata Sons and then goes to all the companies, is a general, cohesive, seamless network. It is not that, yes, you are a Tata company, I am Tata Sons, the principal, and then there is Tata Trust. They are 3 different, but there is a certain tandem movement. Now, you can't just say, I am a chairman of Tata Steel, one of the biggest companies. To hell with anything, I'll do it like this. If that collegiate consultative process had happened, and I think if the prima donna on the other side had shown that maturity, it would not have happened. What is the interference that one man can do at that age? And tell me, Ratan Tata has had his fill. He has been one of the longest serving people there. So it's nothing but a canard. And I think his sense of honor, not his, but a lot of other people's, the kind of things that have been pleaded about him, the kind of things said in defamation suits, etc., which are going on. I think it would hurt anybody who, as you know, his persona is that of a very, very, honorable person.
But, the petition is now, it's kind of come out in public domain, and there's a whole list of issues over which the disagreements seem to have built up, from poll funding to certain business decisions to whether to get into the pizza space to the Docomo deal.
I'll tell you.
What is your understanding? If you were to explain to just people, simply, what is it?
It's obviously difficult to explain very quickly, but let me be very simple. Obviously, I say that the order is wrong, which has now come. Obviously, the Supreme Court will decide. Obviously, I'm not giving you a prejudgment on sub judice matter. But the judgment under appeal in Supreme Court holds virtually that a minority of 18% will have a veto. Now, that is contrary to a fundamental one-line rule in corporate law, which every first-year director and 30th year emeritus chairman knows, majority rule on the board. If I start having to have your consent, no board can work. Second, it virtually directs you to give a preference shareholder or 18% shareholder a primacy in the whole system. Thirdly, and most importantly, the protagonist on the other side has been a director for over a decade and a chairman for over 6 years. Now, this point is forgotten. Let us say there are a laundry list of 5 items. There are about 10, but I'm giving an example of 5. Docomo, Jaguar, Shiva, Shankar, blah, blah, blah. For all of these, for 10 years you are director, please show me a single minute where you objected. And of those 10 or 12 years, 6 you are chairman. Please show me. So look, Barkha, you can be wise by hindsight. It's always 20/20 hindsight. When you're no longer chairman, you can go and say this whole thing is nonsense. But you were a chairman right through. They're all running, for 12 years they're running under your nose, right?
Yeah.
It was so bad you had to completely come up and stop it. At least dissent, at least express a view to the contrary. It can't be that after you are out, everything is wrong. When you are in, everything is right.
What was, if you had to explain what disturbs your client, in this case, Mr. Tata, the most? Is it his reputation? Is it the reputation of the Tata legacy?
I think, first of all,
what is this Tata ethos? This is a phrase you've used in the interview.
He said, it doesn't matter what disturbs me. This is a corporate, collegiate matter. It must disturb the board as a whole. Remember one more thing. I have removed you on a board where there is not a single vote in your favor. Not a single vote in your favor.
Yeah, I read
one
that.
abstention.
Yeah.
All other votes against you and 1 or 2 people who did not participate. Now, therefore, there's a collegiate decision. If you ask me a personal question, I can't go into his mind, but I think what disturbs him the most is the word he used, legacy of Tata's, which is a very cohesive, consultative, collegiate legacy.
But not a legally definable one. So how do you argue it in court?
No, the answer is simple. That's why.
You're again saying it doesn't matter when the numbers of the board.
No. My point is made out by that. That is why you defer to the majority wish of the board. No court can second guess.
So let's say
whether a collectivity of a board wants you. Can I impose you on a board which is unwilling?
So let's say Cyrus Mistry was indeed running everything per the Tata legacy, but Ratan Tata still wanted him out. You're saying that if the board decided that, so be it.
Absolutely. Of course, if the board decided that in a minute it wrote, I will not want Barkha because the color of her hair is not brown, then it is judicially reviewable. Or if it said, I am removing Barkha because she did not do something contrary to the Companies Act.
Yes.
But absent these kind of examples, that's the whole point from Escort's judgment onwards. Majority rule can't be second guessed by judges.
So why do you think the case is reopened? Why do you think the judgment went the way it did?
I think it's clearly wrong. I mean, just consider, you are also saying that corporate majority, there is a whole para in the judgment which suggests that corporate majority is worthless.
Yeah.
Now, I mean, it has to, see, this is my view. At the moment, the judgment stands against me. The Supreme Court has equally stated. So, Supreme Court will decide that. So, you do discount my view, but you have heard in the corporate world that many principles anathema to corporate world have been adopted in this judgment.
Okay, last question. We're almost at the end of the interview. There's a chapter on the Uttarakhand and Karnataka cases, really important for the Congress party. You were able to save the day, literally, for them. But the other interesting thing in these chapters is that a time of deep cynicism about the judiciary as an institution, and, sections of the Congress have even taken on a previous Chief Justice and so on. I want you to come in on that larger debate. We've seen voices like Justice A.P. Shah also weigh in, talking about delays that the present court is taking in deciding or even hearing some critical cases. Where is your confidence today as a legal luminary vis-a-vis the Supreme Court or the other courts?
See, I have spent a lifetime here. I am a reasonable person, I think, because I'm a centrist, as Margaret Thatcher said. You have a danger of being struck down from traffic from the right and the left. I don't believe in taking extreme views. But despite that, I am not very happy with the confidence level in the Supreme Court by outcome. Now, that may be wrong or right.
Explain that.
The confidence level is not measurable by a thermometer. It is just there. I would be lying to you if I said that the confidence level in 2020 in the Supreme Court, and I say it with regret, because I have actually very high confidence in the system. But the confidence level, if you take a poll generally, is still the highest in the country. But you ask yourself, is it the same at 5 years ago, 10 years ago,
so why has that
20 years
happened?
ago?
Why has that happened?
There are a series of things. It may be few things by an individual. It may be many things by many individuals.
What has disturbed you the most recently?
I think in the Supreme Court, we have outstanding people, but what is disturbing is occasionally the appearance that when push comes to shove, the spine needed is not always shown.
For example, in which case?
I can't be more specific. You know the kind of examples. See, in 90% cases, push comes to shove is not the issue. You stand by your judge and the judge stands by the system and the system stands by you only when push comes to shove. And I'm not saying that it might not be bona fide, but the appearance and the reflection and the perception given has to match that also. Secondly, I think it is becoming too lawless, individualistic and ad hoc.
Those are strong words.
Yes, because I mean, you take a view because you are Judge A, I take a view as Judge B. That longer term perspective. Third, I think real scholarship is missing. There are some notable exceptions on the Supreme Court. And there is a second category which has the capacity for it. But demonstrably, the scholarship part of the Supreme Court has to increase. Having said these three things, there is no doubt that if any institution I was to put my life by, it would still be the Supreme Court. But in relative terms to its own high standards, it has diminished. It is no point saying we are still the most believed in institution than the executive. I would say, so what? And more than the legislature. Again, so what? Certainly more than even journalists.
Are there specific cases or media? We can have a whole another 1 hour on the declining credibility of the media. Is there any particular case where you felt that that absence of spine or that ad hocism was visible?
There have been cases.
Would you name one or two?
No, I won't think it will be fair in this quick way to do it. There have been not one, there will be more than one. But I think there is also a writing of the balance as time goes by. I think internally there are people who realize it, and ultimately I am against external impositions in the Supreme Court.
Yeah.
That awareness is growing in the Supreme Court, it is going to happen internally. It is already happening. So the only thing is that the inflection point has to be balanced with the right goers and not the wrong goers.
Maybe that'll be the subject of your second book. Thank you so much, Abhishek. Pleasure. And lovely read.
Thank you so much.